Just by way of introduction, I'm Rama Appadoo, the new Registrar of MARC since December of last year. And I'm very pleased to actually invite Mr. Mohammed, Zaman, Queen's Counsel, and also Maria Mulla of Number 5 Barristers Chambers in London.
So it looks like so far we have some people joining from London. It would be great if everyone can keep updating the chat as to where everyone is joining from, because I know we've got people coming from all over today, haven't we, Rama?
Yes, we do actually. It gives me actually, I was very pleased with the list of attendees who signed up, and people from across the world who registered, such as Kenya, Azerbaijan, United Kingdom, Mauritius, of course, India, Rwanda, Iran, St. Vincent and the Grenadines. All these places, people just signed up for this webinar. The webinar today is on 3 important topics, which we will call it the hot topics in international arbitration, mainly the arbitral bias, misconduct that happens in international arbitration. That will be discussed by Mohammed, Zaman, and also the seat of arbitration, which will be taken by Maria. Like I said, I'm the new Registrar of MARC, and the reason why we picked those 2 topics, we believe, are of great importance, especially the arbitral bias. As you know, arbitration is hinged on the impartiality of an arbitral tribunal, or if it's a sole arbitrator, that will be the impartiality of the sole arbitrator. And all parties would like to have a fair resolution of the dispute. And since 2020, we've seen an important case that came up, the Halliburton case in Chubb, where there was a case of bias that came on the table, impartiality of the tribunal as well. So if we go across the board and looking at the arbitration law comparatively between Mauritius, for example, and England, it's embedded in the law that the duties and powers of a tribunal is hinged on the fact that parties would like to have a fair resolution, and also avoid unnecessary delays and issues in the arbitration proceedings. Also, we've chosen seat as an important hot topic that will be discussed by Maria, because we believe people a lot of times get confused between seat and the venue and the place. And also it gives the seat, also we call it, brings the home for arbitration and gives the nationality of the award. So, which is very important to look at what are the supervisory jurisdiction over the award and how we protect the arbitral award and its enforceability. So these are important topics that will be discussed by our 2 panelists. Let me give a bit of introduction on who are those panelists. So Mohammed Zaman QC is, of course, the Queen's Counsel at Number 5 Chambers, London, and one of the largest barristers chambers in England. He's a fellow of the Chartered Institute of Arbitrators, a registered practitioner in Dubai International Financial Court, a director of the Turkish British Chamber of Commerce, and chairman of the Midland and Chancellor Commercial Bar Association. He was appointed Queen's Counsel in England in 2009, and has a broad commercial litigation and international arbitration practice, covering a wide range of contractual, shareholders, joint venture, property, and regulatory disputes. He's ranked by Chambers and Partners as a Band 1 Queen's Counsel, and they say of him, he's hugely respected silk with high-level experience in commercial court proceeding and international arbitrations. An outstanding advocate, and the man you want to have on your team at trial. A vastly experienced and charming silk who leaves no stone unturned in his preparation and is ruthless in his cross-examination. I mean, we can all read about bias and misconduct in books or on magazines or international arbitration journals, but I think the reason why we have Mohammed today in this panel is because he wanted to share more experience as an arbitrator himself and some anecdotal experience that he actually experienced himself in Dubai. Hopefully we have time for that. And Maria is a barrister at number 5 Chambers, who has been called to the bar in 2005, and she specializes in commercial litigation with emphasis on international work and dispute resolution, including mediation and arbitration. Maria is also a registered practitioner with the DIFC courts in Dubai. Actually, Maria and I, we met in Toronto some years ago at a CIRB function. And she'll be pleased to actually share her experience and on the seat and also other topics in international arbitration in the future. But today we can actually focus on the seat of arbitration. Without further ado, I think I'll let you. I don't want to steal your show, so I will let Mohammed take it from here and talking about arbitral bias and misconduct in international arbitration. Mohammed, it's yours.
Rama, thank you very much for your kind words. The topic that I've chosen, arbitrator bias and misconduct, it is in truth a very wide topic, and I doubt I'll be able to do it full justice in the limited time, not least because the nature of international arbitration is such and so diverse that there is no single one-size-fits-all test for what amounts to misconduct or bias. None of the national arbitral statutes refer to misconduct, but they do typically have a provision that allows a challenge to the award on the grounds of serious irregularity, as for example under the English Act, or in Mauritius, for example, on the grounds that there has been a breach of the rules of natural justice during the arbitral proceedings. I'd like to just focus on two types of misconduct that could take place in an international arbitration. The first is where perhaps the tribunal is inattentive and it isn't unknown for an arbitral tribunal to fall asleep. Or secondly, where the tribunal interferes with the presentation of the case. Let's start by looking at two of the leading English authorities on inattentiveness. Inattentiveness is a euphemism for either being drunk or asleep. And let's see how the English courts deal with those circumstances. So the first case I'm going to look at is a case called Stansbury and Datapulse, which is an employment case in England. Mr. Stansbury had a claim for unfair dismissal. He presented it to the employment tribunal. His claim was dismissed. He asserted on appeal that one of the lay members, there's a 3-panel, as in the English employment tribunal has 3 members, one of the lay members appeared to be drunk and had fallen asleep. He didn't raise that issue during the hearing, and his appeal to what was called the Employment Appeal Tribunal was dismissed, and the case then went on to the Court of Appeal. Evidence was adduced before the Court of Appeal, which included a statement from the chairman that he could smell alcohol in the breath of the lay member. There was no denial by the lay member that he'd been drinking during the course of that day, and a statement from Mr. Stansbury's barrister that the member had been animated, namely that he had shuffled about a little bit, made facial expressions, and occasionally made some comment to the chairman. The Court of Appeal, unsurprisingly you may think, allowed Mr. Stansbury's appeal, with the Lord Justice Peter Gibson saying it was the duty of the tribunal to be alert during the whole of the hearing and to appear to be so. And he said, it seems to me to be an analogy with the cases of bias as appropriate. In cases of bias, the appearance of bias, as observed through the eyes and ears of a fair-minded and informed observer, will vitiate a hearing. Now, you may say, well, that's common sense. Is there a case in the other direction? Well, there is, because this very issue arose in the context of a criminal case in England. It's a notorious case. Nobody will ever remember the name of the individual. His name was Betson. And of course, the case is the well-known case of the Crown and Betson. Mr. Betson's name won't live in infamy, but what he did or tried to do was infamous. You may all be familiar with the Millennium Dome in London. There was a display of gems at the Millennium Dome worth some £200 million. And Mr. Betson had been watching perhaps too many James Bond films and had thought that it would be a great idea for him and his friends to modify a JCB, ram into the Millennium Dome, take the diamonds, put them on their getaway speedboat, and presto, they were going to be £200 million richer. What they didn't realize is they were actually under surveillance all of the time. And in fact, the gems had been substituted, so they were never going to get the money. They were caught, they were tried, and of course, there wasn't much of an incentive to plead guilty to an offence of stealing £200 million. So he had his trial, and he was, as you may think, unsurprisingly convicted. However, Mr. Betson was not going to let it lie at that. He decided that he would appeal to the Court of Appeal on the basis that the trial judge had fallen asleep. Now, you may think that that is a remarkable assertion, but in fact, the trial judge had admitted that he had fallen asleep. I mean, the Court of Appeal always asks what the judge for his comments, not that they matter, in finality, but they are taken into account. And the evidence in front of the Court of Appeal was not only had the judge fallen asleep, but that on one occasion he'd fallen asleep so much that he was woken up by his own snoring. And whilst he was asleep, a member of the jury had fallen asleep and he hadn't noticed that either. So you have to ask yourself, in those circumstances, was the appeal allowed? I mean, you've heard the Stansbury decision, it would vitiate it because of the appearance. But the Court of Appeal went on to dismiss Mr. Betson's appeal. And they said, because a judge falls asleep or for any other reason allows his or her attention to wander, it does not necessarily follow that the trial is unfair or that any ensuing conviction is unsafe. It is the effect, not the fact of such inattention, which is crucial. This must in each case depend on the circumstances, including the period of inattention, both absolute and as a proportion of the length of the whole trial. And you can read the judgment to your heart's content, but as I say, notwithstanding all of those facts, the fact that the judge had fallen asleep did not amount to misconduct and would, one by analogy say, applies to arbitration. And in fact, the reason I'm able to give you those two conflicting authorities is I actually happen to be in a case in the Dubai World Tribunal, it's a fair few years ago, where similar sort of events occurred. Three-man tribunal. The proceedings in the Dubai World Tribunal are videotaped. The trial went on, and during the course of the trial went on, and it concluded, and judgment was reserved. After judgment had been reserved, the other party decided that they would appeal, or at the very least, sorry, let me rephrase that, would apply for a retrial on the grounds that one of the wing members had fallen asleep. The videotape was examined. I'm not in a position to say whether or not the judge had fallen asleep, because whether he's fallen asleep is a matter only that he knows. What was agreed between the parties was that the judge was apparently inattentive for a number of minutes, and it was asserted that his head was down and he may not have been paying attention. This was an opportunity for the Dubai World Tribunal to consider the conflict between the Stansbury case and the Betson case, because of course they would lead in two different directions. But the view taken by the special Dubai World Tribunal was as follows. We have no hesitation in rejecting the submission that for some unexplained reason, the English courts apply a different standard in assessing whether there has been a fair trial in civil as distinct from criminal proceedings. If the judgment in Stansbury implied a different test to be applied in civil cases, that any period of inattentiveness, however short, though subject to a de minimis exception, we would hold that the general principle is as stated in Betson. So Betson is now more or less in England the guiding case on the point. And in fact, in the particular case, circumstances of the case that I appeared in, the video recording was there. The judge did appear apparently inattentive. But the real question for the tribunal that was considering the review was whether or not it had any impact. Was anything of consequence missed? And I think if you ask me for a personal opinion, as opposed to reflecting what the authorities say, that must be right, because it is no judge, no arbitrator who would sit and listen to every word that is uttered. we all know when we're making submissions, the arbitrator takes a note of what's relevant. And in fact, the very fact that the arbitrator is writing something down may mean that he might have not heard everything that was said. So those are the two authorities I wanted to deal with on the point of apparent inattentiveness, which would, of course, be a procedural irregularity. I'd like, if I may, just briefly to turn to interference in the presentation of a case. Of course, that is or may amount to a serious procedural irregularity, depending upon the nature of the arbitration. I mean, as we all know, the rules of the arbitration are subject to all sorts of powers, and the parties may agree that it might be an inquisitorial arbitration. The parties might agree that the arbitrators examine the witnesses. But if, in fact, you follow the normal adversarial principles, then, of course, you really need to be aware of the English approach to interference in an adversarial process. And I'd like to just refer to a case that actually goes back a bit. It was before I was even born, the case of Jones and National Coal Board, which was a case involving a widow of a coal miner who'd been killed by the falling of a roof. There'd been a fall of the roof some weeks prior, and the conditions had been restored completely. Chocks had been used, and a major issue was whether it was good mining practice to use chocks. When the manager gave evidence on behalf of the coal board, the judge effectively took over the examination of the witness for nearly a day and a half. When the witness was being cross-examined, the judge interrupted cross-examination, which was described by the Court of Appeal as, quotes, protecting the witness. And when the engineer was called, Lord Denning, or Lord Justice Denning as he then was, said, "We're afraid the judge took the examination in chief largely out of the hands of counsel. He took the points of criticism made against the defendant and went through them with the witness and appeared to accept his explanations." And that really is, if I may describe it in simple terms, what's called descending into the arena. It is not for the arbitrator or the judge to get in there in an adversarial process and take a side. And that is effectively a serious procedural irregularity, or it would be in my submission if such circumstances arose. I'd now like to turn, if I may briefly, and I know I'm going to be running out of time eventually, to the question of bias. Starting position, of course, is very simple.
Let me interject here 1 second. Mohammed. The people who are attending this webinar can also send their questions through the Q&A, and we will address them as we progress through the webinar. Thank you.
Excellent, and I look forward to them. I'd just like to turn to bias. As I was saying, the starting position is simple. Virtually all institutional arbitrator appointments require some form of declaration of independence, whether it's ICC, LCIA, DIAC, or MARC. In fact, let's just, because out of courtesy, let's look at the MARC rules of ethics for arbitrators. Article 1 is in plain English. A MARC arbitrator shall act as an independent and impartial judge. Before agreeing to be appointed, the prospective arbitrator shall declare any possible past and present relationships with one or several of the parties, their lawyers, or other arbitrators, reveal in writing any circumstances which might affect his independence or impartiality. And it goes on, it's detailed. It continues to, you have to make declarations during the proceedings. He's not to receive any compensation or benefit other than fees paid in conformity with the MARC rules. And you may think that such plain language is easily understood and that the declaration cannot possibly be open to misunderstanding and misapplication. But of course, misunderstanding and misapplication applies to oaths taken by judges to act impartially without fear or favor. And I am reminded of the words of the 18th century English philosopher Jeremy Bentham, who said the following about oaths: "They are useless. The oath is taken by everybody. Everybody violates the oath and nobody's punished for it. Nobody's ever put to shame by the violation of an oath." With those words ringing in one's ears, I'm now going to focus on arbitrations governed by the English Arbitration Act. And the reason for focusing on the English Act is simply for convenience. The statutes that govern arbitration seated in another jurisdiction, including Mauritius, have similar provisions with some variations as to emphasis and procedure, but they all have an underlying emphasis on neutrality and impartiality. That means it is clear that impartiality is a cardinal duty of a judge and arbitrator. I'm not going to read the section provisions to you, but look at section 33 of the English Act, fairly and impartially between the parties. Look at section 24 of the English Act, which provides for a challenge where there is circumstances exist that give rise to justifiable doubts as to impartiality. So you have your route, you can challenge. If in fact you don't challenge, it's still open to you to challenge the award under section 68 because of the serious procedural irregularity. So the safeguards are there, but how are the safeguards actually applied? It is indisputable that actual bias is a clear ground upon which an arbitrator's appointment can be challenged. But actual bias, or proof of actual bias, is rare. As one judge of the 19th century put it, the courts cannot search into the souls of men. The next most clear ground is where a judge or arbitrator has a financial interest in the dispute. Now, you might think that's always been clear as a matter of law and proposition. No, it's a matter that actually is the subject of a House of Lords decision from the 19th century in the case of Dimes and the proprietors of the Grand Junction Canal, 1852. I have to digress. The facts of that case are as hilarious as anything that could have been reported in the 20th or 21st century. In the 18th and 19th century, canals were the new internet. They were the new mode of transport, a new way of cutting edge technology. Everybody, Tom, Dick, and Harry, was interested in investing in building a canal. And so a new company had been incorporated, the Grand Junction Canal Company. It was given statutory compulsory purchase powers. And in 1797, they acquired a small parcel of land in Rickmansworth as part of their canal cutting. So they were very efficient in those days. The canal was up and running in 1797. In 1831, a fair few years later, Mr. Dimes purchased an interest in land where the canal ran. In 1835, some 38 years after the canal had been operational, Mr. Dimes claimed that he had title to the land. And if they wanted to run the canal through it, they'd have to pay him some money or he was going to obstruct it. They didn't pay him some money, so he threw some chains into the canal and obstructed it. And then began the sort of litigation that would have been bequeathed to one's children and grandchildren. For some 13 years, there was litigation running between Mr. Dimes and the Grand Junction Canal. I hate to say for Mr. Dimes' sake, he lost on every particular application. He was the subject of many petitions that were dismissed, many claims and counterclaims being non-suited. He in fact ended up going to jail. Several of the hearings were in fact in front of Lord Cottenham, the Lord Chancellor. And the Lord Chancellor had actually dismissed those petitions. He was the one who had committed him to jail. In 1849, Mr. Dimes discovered that the Lord Chancellor had actually owned shares in the Grand Junction Canal Company. And the matter was then came right back in 1851, 13 years after the dispute had kicked off, when in fact, Lord Cottenham had been deceased by now, and Lord Campbell in the House of Lords said, no one can suppose that Lord Cottenham could be in the remotest degree influenced by the interest he had in this concern. But my lords, it is of the last importance that the maxim that no man is to be a judge in his own concern should be held sacred. So Mr. Dimes performed a great service to the legal profession, settling once and for all the idea that no man is to be a judge in his own cause. Back to international arbitration. The appointment of arbitrators is considered something of a minefield, in particular, the idea of the party appointment. I'm now going to quote from the case that we all know, Halliburton and Chubb Bermuda 2020, where Lord Hodge discusses this particular problem. And he said, in the field of international arbitration, there are differing understandings of the roles and obligations of the party-appointed arbitrator. He then refers to the lively debate on the point. and quotes from Professor Martin Hunter, in which he makes the following observation, that is, Professor Hunter. When I am representing a client in international arbitration, what I'm really looking for in a party nominated arbitrator is someone with the maximum predisposition towards my client, but with the minimum appearance of bias. In arbitrations where the parties have, or one party has an expectation that the party nominated arbitrator will be predisposed towards it, it is perceived that the person chairing the tribunal, whether appointed by the party nominated arbitrators, jointly or by making an appointment or by an appointing institution of the court, has a particular role in making sure that the tribunal acts fairly and impartially. Notice the twist. Professor Martin is very plain as to what he expects. He does expect his arbitrator to have the predisposition of the minimum appearance of bias, but he thinks that the person who ought to be neutral is the chairman. In Halliburton, Lord Hodge dispelled any suggestion that so far as English law is concerned, that there is any difference in the standards of impartiality between a party nomination and a chairman. I was going to read the quote to you, but I think you can read it for yourselves. It's basically this: once they're appointed, they're entirely independent of the appointing party and bound to conduct and decide the case fairly and impartially. They are not in any sense a representative of the appointing party or in some way responsible for protecting or promoting that party's interests. Having said that, that is not a universally acknowledged principle. And in fact, Lord Hodge in Halliburton cited an American case in the US Court of Appeal Second Circuit, purported to draw a distinction between what is called a party-appointed arbitrator and a neutral, as if the party-appointed arbitrator ought not to be neutral. So it's a live issue. It will always remain live. It depends very much on the arbitral institution. Again, there is, I suppose, nothing wrong in principle if parties wanted to say, if it had actually been in an arbitration agreement, that my arbitrator is going to argue my point. I mean, there's nothing stopping. After all, arbitration, as you know, is contract-based. But I don't think that that is what we expect from arbitrators without any specific assignation to what they ought or ought not to do. So that now turns me to the question of what is the standard of impartiality that is to be expected of arbitrators. We're all familiar with the IBA guidelines on conflicts of interest in international arbitration. They are widely consulted by prospective arbitrators, but of course, as we all know, they do not have statutory force or even application by implication. I do not intend to go through those guidelines, as I'm sure all of you are going to be familiar with them, but I'd just like to quote, if I may, Article 2A. An arbitrator shall decline to accept an appointment, ... if he or she has any doubt as to his or her ability to be impartial or independent. I'm reminded of a joke that is told about a man asking a rabbi to tell him about Jewish law in the time it takes down to sit down. And the rabbi said, it's all very easy. Do unto others as you would expect them to do unto you. The rest is commentary. And indeed, 2A is the guiding principle. The rest is commentary. You really ought to know what you ought to do or ought not to do, but that doesn't stop lawyers and arbitrators from raising all sorts of flags and hurdles. And as we all know, the IBA guidelines cover more than 40 factual situations. There's the traffic light system with red, orange, and green. There's the non-waivable red list, which frankly, if you need to be told it's non-waivable, you really do struggle with integrity. Then there's the waivable red list, which is described as serious but not severe. Then, of course, as you know, the orange list and, of course, the green list, all of which are, of course, as set out in the IBA guidelines, non-exhaustive in any event. Non-exhaustive, put to one side, not binding. Let's have a look at, again, because I'm doing it from the perspective of English assumption that every other jurisdiction has similar provisions. The real development in English law and apparent bias is incremental, and it goes back to a series of 5 conjoined appeals in a case called Loco Bail UK Limited and Bayfield in 2000, where the Court of Appeal took the opportunity to restate that beyond actual bias and automatic disqualification, the most effective right to a fair trial is afforded by the following rule. If on examination of all the relevant circumstances, the court concludes that there is a real danger or possibility of bias, the arbitrator or the judge ought to disqualify themselves. And we all know that that statement of principle was then adopted and expanded on in the House of Lords in Porter and McGill, which is the well-known proposition. The question is whether the fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was biased. The rest is all facts. It is all fact sensitive, and you have to look at individual cases to see how they go in a particular direction. And Loco Bail is a classic example. There are 5 conjoined appeals. I could take you through each one of them. In fact, only 1 of the 5 appeals succeeded in establishing bias. The other 4 did not. And I'm going to give you an example of one of the ones that failed. The reason I'm doing it is it's quite funny. And one of them succeeded. And actually, the success was unexpected. So let's deal with the one that failed. There was one of the appeals involved a man called Mr. O'Callaghan. And I like Mr. O'Callaghan from reading the judgment. He was a man who liked to bet. And he had gone to a betting shop and had placed a £25 accumulator bet at Corals, the bookmakers in Cardiff. The £25 bet would have resulted in him winning £259,500. Not a bad return. When he tried to claim on his bet, Corals refused to honour it, saying that their practice was to photograph the bet. They hadn't photographed it and they weren't going to pay. Then Mr. O'Callaghan began a campaign to put pressure on them to pay. So he objected to the renewal of their betting licenses. He, having objected, failed to turn up at court. Having failed to turn up at court, if you objected, you are then actually exposing yourself to costs. He didn't turn up, sent in a doctor's note and asked for an adjournment. The doctor's note didn't get him the adjournment, but it did get him a £5,000 costs order against him. And he then tried to appeal this. He appealed it to the wrong court, the Crown Court, which had no jurisdiction. Having been told by the Crown Court he ought to go for judicial review, he applied for judicial review. It was granted, permission was granted, but he failed to serve it in time. And in the meantime, Corals carried on in business. He then made an application to extend time, and it came before the Honourable Mr. Justice Dyson, who in fact became a Supreme Court judge. And Mr. Justice Dyson said this was not really about the substance of the case. It was about the fact that he'd been ordered to pay £5,000 and didn't like it. It was a modest sum of money, and his permission application to extend time was refused. Mr. O'Callaghan liked to read the Times newspaper, and he'd read in there that Mr. Justice Dyson was in fact a director of a company that owned properties, and that one of their tenants were Corals, the bookmakers with whom he had placed the bet. And the argument was to the effect that Mr. Justice Dyson had an interest in the outcome of the litigation because, the company would be getting rent. The true facts were that Mr. Justice Dyson was a director of a family property company. It wasn't commercial directorship, and they had many tenants, and £5,000 was not a significant sum. The Court of Appeal dismissed that, saying that there was no apparent bias, notwithstanding that rents would be received. The one that succeeded was really, I'm very mindful of the time. I'm just going to run through the principle rather than the...
I was just going to say, Mohammed, I think,
yeah,
just for the interest of time.
I'm just going to run through the principle. The principle is this. It's about writing articles. In Timmins and Gormley, the judge, who was a part-time judge, had a habit of writing articles outside in his private practice. He'd written articles that insurance companies didn't like, because of course he was very critical of insurance companies. He was trying a case with an insurance company on the other side. They appealed effectively on the basis of his extrajudicial statements. And the Court of Appeal said that he'd crossed the undefined line in the articles that he'd written, and really he could not have sat on, it was apparent bias, because insurers couldn't feel comfortable that they would get a fair hearing. So in fact, if you take that analogy, look at the way your proposed nomination is going to behave. Has he written articles saying, I always find against claimants or I always find against defendants? It does actually have an impact. So that's the principle. I am mindful, as I say, that I don't have much more time. And the only point I would like to deal with, just 1 minute on it, is waiver. Waiver is really quite important. And I have to say this, and I'll leave you thinking about it. Waiver has to be informed waiver. It's not merely that your lawyer has waived. It's the waiver is the waiver of the party who has to know all the circumstances. So think of the situation where a legal team say, we think you're okay. Actually, what needs to be demonstrated is that the party understood and waived. I think that bearing in mind, I've significantly overrun, apologized to Maria, and apologize to everybody for the content of my talk in any event. I'm going to hand over to Maria.
That's fair. That's fair and interesting discussions and sharing of experience in anecdotal cases. One of the questions from the Q&A would be to share those references to the cases, if possible, if you can tie them.
Certainly. What I'd like to say is you have my email. I'll type in my email address. Anybody wants the list of authorities, I will be happy. There's actually so many more. I've skimmed.
Just before I let the floor to Maria, just a quick question in terms of one of the questions also is to do when you said about the waiver, parties should be aware of that. Is one of the questions was should there be a limitation to party autonomy in international arbitration when avoiding complication in procedural part of the arbitration process? And what's your opinion on that from that as far as limitation on party autonomy in international arbitration?
That's as Eddie, I'm sure we've all been there. That is a compound question.
Yes. Yes.
There are several questions in that.
Yes.
A party autonomy it's a
huge topic.
It is a huge topic in itself.
Yes.
The principle of arbitration, remember, it is contract-based. Parties can agree to do anything that they wish within the framework of the legislation. So, which is why I was very careful not to say anything applies specifically, because we can, I mean, in theory, there is nothing wrong with having an arbitrator who is appointed, who is going to be an advocate of the parties and who is not impartial, because if that is what the parties agree, it is there, it's defined, not a problem. If parties want to limit the way in which it works, that's why we have institutional rules. I mean, the very raison d'etre of MARC and other institutions is to avoid having to reinvent the wheel every time you have an appointment. I mean, ad hoc appointments, as you know, are something of a nightmare, because you then have to basically start saying, these are my rules, this is what I'm going to do, this is how it's going to function. Can we have a preliminary hearing on that alone, please?
Yes. If I may now switch to Maria, who's going to give her talk about seat of arbitration.
Yes, thank you, Rama. And thank you, Mohammed. That was very insightful. It's really, really good to hear your experiences. So I'm talking about the seat of the arbitration today. It's a relatively short topic, certainly much shorter than Mohammed's, but it's vital to the arbitration proceedings. And unfortunately, it is an aspect that may often be overlooked by the parties when negotiating the terms of the agreement itself. It may slip to one side as the parties focus on another part of the clause, which will mean that the seat may often be overlooked as part of that negotiation. But in fact, the actual tactical consideration of the seat and the choice of the seat may actually help a party obtain their individual objectives. So therefore, it is something that should be given paramount consideration, I say, when negotiating the actual terms of the agreement itself. So what is the seat? Some people may think that the seat of the arbitration is simply the physical place where the hearings take place. However, the seat of the arbitration is not a matter of geography, and this was confirmed in the Peruvian insurance case, where it was stated that it may often be convenient to hold meetings or even hearings in other countries. This does not mean that the seat of the arbitration changes with each change of country. The legal place of the arbitration remains the same, even if the physical place changes from time to time, unless the parties agree to change it. And it is not unusual to have a seat in one jurisdiction with physical hearings taking place in another location. And there is some support for this in the actual drafting of some of the rules. Specifically, the Icc Rule 18 states that the arbitral tribunal may, after consulting the parties, conduct hearings and meetings at any location that it considers to be appropriate. There is also a similar provision, and Rama, I've been doing some research into the MARC rules and Rule 16.2, which states that the parties are able to meet at any location outside of the seat of the arbitration, which it considers appropriate for consultation amongst its members, and this may be for the purpose of hearing witnesses, experts, or the parties, or, for instance, to consider property or documents. Because the reality is, in many arbitrations, that parties may be based in many different locations at any one time. And there may be occasions when the tribunal may have to travel to another jurisdiction to visit, for instance, the site of a project, but this will not change the seat of the location. Because essentially, the seat of a location is not at all about the geographical location. The seat of a location is the actual legal home for the arbitration itself. And it is often referred to as being the actual anchor of the arbitration. So I think it's important to consider a little bit about when a party is agreeing to the seat of the arbitration, what exactly the parties may be agreeing to. The negotiation and selection of the seat of arbitration will effectively determine which country's laws will apply to some of the practical aspects of the arbitration itself. When selecting a seat, the parties will be placing their arbitral process within the framework of that state's national laws. For instance, in England, Section 3 of the Arbitration Act provides a helpful definition of the seat of the arbitration as effectively being designated by the parties to the arbitration agreement itself, or by the arbitral tribunal if authorised by the parties, or the seat may be determined in the absence of any such designation, having regard to the parties' agreement and all the relevant circumstances. And it's important to note that the reality is that the national framework effectively anchors in the arbitration process and assists in filling in any gaps that may exist in that process. For example, a national court will be able to take many steps, including, for instance, providing procedural directions if needed, providing the availability of interim measures and the granting of emergency relief. For instance, if a freezing order is urgently needed to prevent assets from being dissipated pending the determination of an award. The seat will also determine how the award will be recognised and enforced. And It can also be argued that the selection of a good seat may actually give the arbitral tribunal some actual real teeth in the arbitration, some real strength and support. And within the seat of England and in London, the Arbitration Act contains some mandatory provisions that apply to the arbitration regardless of the arbitration agreement itself. And these really help give the arbitral tribunal some support. And some of these powers include the power of the court to remove an arbitrator, the power of the court to determine a preliminary point of jurisdiction. Under Section 42 of the Arbitration Act, where a party has refused to follow a peremptory order of the tribunal, an application may be made to the National Court requiring compliance. If a party still fails to comply, this may result in contempt of court proceedings being commenced. I've also, again, been having a look at the International Arbitration Act in Mauritius, Rama, and there are also contained within that act some mandatory provisions. For instance, interim measures ordered by arbitral tribunals must be enforced and recognised on any application to the Supreme Court, and that is Section 22. Under Section 23, the Supreme Court in Mauritius has exactly the same power to issue an interim measure in relation to arbitration proceedings as it does in the court. So some real strength there and support to the arbitral process being provided by the actual provisions of the national courts and the national jurisdiction. So there is some debate in the academic community as to whether or not the actual seat of the arbitration is starting to lose its significance, because if there is an arbitral tribunal, which is a self-regulating tribunal, it's self-governing, why should it not simply be able to float free, separate from the national laws and the national courts? But I will say, and hopefully I've demonstrated by some of the things I've spoken about, that if a correct seat is chosen, if a safe seat is chosen, the two can work together in perfect harmony. And also, this enables the party to help to keep the arbitration under their control as much as possible. So how do the parties decide on this seat of the arbitration and what is regarded as being a safe seat? And I think it would be helpful if the participants at this stage could pop in the chat box what is their seat of preference. And Rama and Mohammed, I'll be coming to you at the end to find out your seat of preference. So the seat of the arbitration should be a very conscious choice of the parties, as there may be both legal and tactical considerations as to why one seat may be selected by the parties over another. The seat will also determine where an award has been made, which is a significant factor for both the recognition of the award and then the enforcement of the same. There are many places, as we know, around the world competing for arbitrations. So what makes a seat a preferred one and a safe one? In 2015, the Chartered Institute of Arbitrators published the London Centenary Principles. And the whole aim of these principles was to try and identify characteristics which provided details of what the parties should be looking for an efficient, effective, and safe seat of the arbitration. There are 10 principles in total, but I'm only going to refer to a few of them, but we can get the general gist that effectively what the principles were saying was that a safe seat would have an arbitration law which provides a good framework for the process, limiting court intervention and striking the right balance between confidentiality and transparency. There will also be an independent, competent, and efficient judiciary, ready access to the country for both witnesses and counsel, and a safe environment for participants and their documents. Well-functioning venues for the meetings and hearings, and the adherence to treaties for the recognition and enforcement of foreign awards and arbitration agreements. It is also important when having a think about what seat a party may want to opt for is the ultimate objective. If a party wants to achieve ultimate finality in the proceedings, they may wish to choose a seat which can provide that finality with limited rights of review of the award. And I think, Rama, you correct me if I'm wrong, but Mauritius is known as being a seat of arbitration which has good finality.
Yes, that's for sure, especially being a signatory of the New York Convention and the non-interference of the local courts, which gives a party reassurance, and also the laws are in favor of arbitration. That's an important thing, and enforceability. I think it's about the legitimacy and the credibility of an award, and Mauritius has that state of the art arbitration law that provides for it. Yes.
Yeah. So whilst we're on the topic, I mean, Rama, you've started us off there talking about the benefits of Mauritius, but what other factors make Mauritius a safe seat?
I believe, I'm sorry, can you hear me yet? Mauritius is, besides the dichotomy system of legislation we have in Mauritius, it's the state-of-the-art law legislation in arbitration, especially the fact that we have a provision in section 43 of the International Arbitration, how we provide 6 designated judges that will only take care of international arbitration, which is prominent in terms of legislation, and also the fact that the courts are pro-arbitration, so there will be no interference in the proceedings of arbitration happening in Mauritius. Mauritius is a signatory of the New York Convention, and we respect the procedural laws of what parties choose, especially the fact that Mauritius has 2 or 3 institutions with MARC and MIAC and a PCA here in Mauritius. So besides there's so many other benefits coming to Mauritius, I think using Mauritius as and also the fact that you can protect the award and also have a enforceability through the New Convention being a signatory again. So yeah, some of the other reasons why you should choose Mauritius as seat, and especially the fact that it's a beautiful island as well.
and I was going to say, from an arbitrator's point of view, at least you're not likely to be arrested.
Exactly, and also we've not put any I mean bars or like limitations in terms of coming as foreign lawyers to come and practice at the court here when it comes to the arbitration. So there's a little bit of a leeway and a welcome to foreign arbitrators to present.
The reason I mention arrest is, as you know, for a short period of time, the United Arab Emirates had a law that, against, they made it a criminal offense for an arbitrator to be biased. So could you imagine taking an appointment and an allegation being made that you were biased? It would result not just in your being removed, but arrest and potential consequences. So I think they've repealed that law.
So Mohammed, whilst I have you, what is your seat of preference?
Where I am now.
That's understandable.
In all seriousness, I don't have a seat that I would say has my preference, but of course, starting position for us is London, because London has a historic setting for international arbitration. It fulfills all the rule of law requirements. It is actually the rule of law that determines whether or not somewhere is a safe place where you will get an award that will be upheld. Mauritius vies for that position. As we all know, Singapore vies for that position. And there are other jurisdictions that do so. For me, the seat is important, of course it is, because you don't want an award that's likely never to see the light of day.
Yeah.
But yes, MARC is a perfectly good centre. Mauritius works. I mean, you've got a great catchment area in Mauritius, haven't you?
Yes, I do. And especially the fact that, I mean, one of the specific feature of the International Arbitration Act is the 6 designated judges, especially catering for international arbitration. So you have a reassurance, and also the appeal will go to the judicial committee of the private counsel. So that's also important as well.
Yeah.
Parties to see that as reassurance, credibility, and legitimacy of the system here.
Yes, I mean, it is a shame that some people don't quite understand the distinction between seat and venue, notwithstanding they're in, they practice in international arbitration.
Yes.
It's something that people need to be reminded of occasionally.
Yeah, absolutely. And there was a case actually that I was going to go on to speak about. It was the case of PID and the Federal Republic of Nigeria. And this was where the arbitration clause didn't refer specifically with the words seat of the arbitration, but it simply referred to the venue of the arbitration as being London, England. And Mr. Justice Butcher stated that this actually, the words venue of the arbitration being London, England, represented an anchoring of the entire arbitration to London, rather than indicating that simply the hearings should take place there. So that was enough for him to be able to use that as the anchor to create that as the seat of the arbitration.
Well, one of the great topics that will never ever be resolved in international arbitration is badly drafted arbitral clauses.
No, absolutely.
Yeah, midnight clauses.
I mean, how many have
prizes.
you seen over the years where you read it and you think, well, I had one where they referred to an institution that just didn't exist.
Oh yeah, I've seen those. Just going back to one, I have one quick question for you, Mohammed. When it comes to the bias issue, how much weight do you think you've seen in your experience as an arbitrator that people have casted on the IBA guidelines I was referenced? Have you seen prominence in terms of weight?
The IBA guidelines are,
although it's non-binding, yes.
They are, well, the guidelines themselves, I think it's Article 6, I can't remember which one, the article themselves say they are not binding, because of course they're not. They are just guidelines prepared by the IBA. But they are a point of reference, and they are an internationally recognized point of reference. I mean, even when I'm considering an appointment, I look at them.
Yeah.
I remind myself what they say. When I'm thinking, is it green? Is it amber? It at least gives you a point of reference. There is an English Court of Appeal decision, first instance decision that says, well, they're not relevant, but actually they are. And Halliburton tends to suggest it is. Of course, it's not statutory, but it's there. You cannot ignore a sensible list that is prepared by serious practitioners who are respected. It is a guideline, but then, that is all that you are ever going to get. You are not going to get a proscriptive list. And in fact, the IBA guidelines themselves say they are not proscriptive. There are always going to be circumstances that are not considered. I mean, it does actually always come down to being fact sensitive. What is happening in your case that allows you to carry on accepting the appointment and continue? I mean, on Halliburton itself, the major institutions had vied in a different direction. The decision in Halliburton did not follow what the Icc were arguing for. It didn't follow what the Chartered Institute of Arbitrators was saying arguing for. In fact, one of the criticisms made, it was a mild criticism, was the Chartered Institute was actually not only arguing points of principle, but saying the outcome in this case ought to be for recusal disqualification. So yeah, I mean, they are a very, very important, the guidelines are very important.
Right, well, it does look like we are 1 minute past the hour. So are there any other questions?
There's a question for you, Maria, in terms of venue. Is there a possibility, can the award be challenged if the procedural laws of the seats were neglected? But for one of the attendees, just a reminder before we close this session, all the attendees will be sent a feedback sheet to fill out in terms of what experience has been with this webinar.
Yeah, absolutely. And I think also, Mohammed and I, we won't put we can put our our email addresses in the chat box, but our email addresses will be sent to all the participants of the seminar so that everybody can email us with any queries. I note some of those queries there. Sadaf, your queries, you've got a few of them. They're quite extensive, and I will respond to you via email if that's okay, just so you're getting a full answer and I'm not giving you something effectively off the hoof. That would be my preference there. But if anybody else has any queries, please feel free to contact us.
Thank you, Mohammed. Thank you, Maria, for your time. It's been very, very educational and also very practical. A lot of experience being shared. I think thanks for a great collaboration with number 5 Barristers Chambers. I look forward to more topics to discuss in the future.
Yeah, and Rama, I look forward to coming to Mauritius in person.
Yes, very soon. Very soon we'll be open, hopefully. We're looking into July to open the borders. Hopefully everybody will be vaccinated.
Yeah, wonderful. All right, thank you.
Thank you, guys. Thank you. Bye-bye.